Thank you for joining us today for our webinar. Your commitment to advancing mental health care is truly inspiring. At Iconotes, we're passionate about providing mental health professionals like you with the most clinically robust and intuitive mental health care software available. From psychiatrists to therapists, nurse practitioners to social workers, Iconotes offers a comprehensive solution tailored to your practice's needs. With Iconotes, you can write a flawless note in less than 3 minutes, and without typing a single word. Iconotes was designed specifically to help mental health professionals write comprehensive notes quickly. Iconotes also provides a complete practice management solution with user-friendly scheduling, secure document management, HIPAA-compliant messaging, a certified patient portal, and more, so you can spend less time on paperwork and more time helping your patients. Try us free at iconotes.com/try-us.
All right. Thank you, everyone, for joining today. Thank you, everyone, and already for the comments in the chat. We really appreciate you. I would love to find out where everybody's from. So if you don't mind sharing, if you put your state, your location in here, that'd be great. Also, if you feel comfortable doing that, you can put if you're a clinician or not and what kind of discipline you are. So happy to have you here. Good morning. Good morning. Excellent. Well, as you're doing that, I'm just going to introduce myself really quickly. My name is October Bulls. I'm a DNP, and I'm the Chief Clinical Officer of Iconotes, which is an industry-leading EMR. And my job is I specialize in compliance and clinical documentation. And in my past kind of life, I did risk mitigation for behavioral health professionals. So I do have decades of experience, which kind of tells my age. I'm not super happy about that, but I have had the opportunity to work with thousands of clinicians and help them really master documentation and have best practices to safeguard their license and to help reduce liability risk. And so also in my previous life, as I served as a behavioral health expert for a law firm, and we defended clinicians. These weren't for patients or clients that were suing. These were for clinicians, hospitals, large practices. And that really gave me some crucial insights into malpractice defense and compliance strategies that will help you avoid those areas. I also have the opportunity now to work closely with federal and state agencies. That's like the FBI, Attorney General's offices. I do that nearly bi-weekly. And that has really helped me understand even further where documentation plays kind of a critical role. And so I've seen some of the firsthand pitfalls that lead to legal trouble. So I'm here just to help share practical strategies to help you protect yourself, your practice, and your patients through airtight documentation and compliance. So I'm excited to be here today. I'm excited to have you guys here today, and hopefully will help you navigate some of the complexities of clinical documentation and safeguard you from lawsuits and regulatory scrutiny. So I just want to call out some folks here, some folks that I know in the webinar, but also a lot of folks good here to have you. Hey, Ms. Walden, good to have you in here. And then we've got folks from Alabama, Maryland, great to have you here, PA, Texas. It's fantastic. We've got health IT compliance management folks in here, compliance and billing. Great to have you in here. Psychotherapists from Canada. Love Canada. All right, excellent. Oakland, California. Fantastic. Greensboro, North Carolina. I am your neighbor. I am your neighbor. I am in Charlotte, North Carolina. So it's great to have you in here. But folks really from all over, all types of disciplines too. I'm seeing LCSWs. That's fantastic. NPs, PAs, the LMFTs, excellent. Psychiatrists, great to have you in here today. Wow, the list, lots of folks in here today. We had over almost 800 people register for the webinar, so I knew there'd be a big crowd, and I am so happy to have you in here. Great, 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 great. All right, well, let's go ahead and get started. I am going to talk about a little bit about why this matters and some concerning trends, and as you can see, there. I like to use a lot of statistical data when I'm talking in the webinars. And so as you can see, you're looking at psychiatrists are facing malpractice claims. And listen, I do want to point out that it is, if you're in mental health, okay, it's significantly lower than high risk specialties like neurosurgery, where like 20% of practitioners in neurosurgery face claims each year. Okay, every year. And I'm going to use terminology, and I want to go ahead and clarify it, that there is overall career percentages, and then there are annual yearly percentages as well. So, but I do want to also talk about with psychiatrists. One of the things that worries me about psychiatry is that even though maybe folks don't get sued as much, they're more likely than other specialties to face disciplinary actions from state medical boards. And the same is with nurse practitioners. So that's really concerning. That's really concerning. Now, when we talk about litigation process, the majority of malpractice cases are settled out of court. So I want you to know that most of them are settled out of court. And even when they do go to trial, physicians in general, including psychiatrists, often prevail, right? But what I want you to be very clear on is that litigation still imposes such a significant emotional and financial burden for those who are involved. I mean, it's just crushing. And so I think that unfortunately in mental health, and I do want to encourage you guys to be active in the comments, because right now in this room, there are a lot of people that are extremely educated and have, I'm seeing 43 years of experience, a lot of experience in here. So I want you to be really active. Give me your thoughts and opinions as well, because there's a lot of smart people in this room right now. Okay. And you've seen a lot of things, right? And I think it's good to share that. So I don't want to be the only voice in the room. But I do want to say, and this is the only part in the webinar that I'm going to kind of go dark, but I am going to talk about it a little bit, what I think we're going to see as far as malpractice health go up and the reason why. Now, in my webinar, I'm going to give you nothing but statistics and evidence-based data because I believe firmly in that. So right now, what I'm going to give you, 60 seconds, is just my opinion. You may not agree with it. And to be honest with you, I hope I'm wrong. I hope I'm wrong, because if I'm not wrong, a lot of people are going to get hurt, unfortunately. But there is a very, very, very troubling trend right now on social media. And you go on TikTok or any social media, and what it will involve is patients or clients, and they're like publicly talking about their intent to sue their therapist or to sue their doctors or their nurse practitioners or PAs. And these videos that they give are like short 1 minute, 2 minute clips. It's limited. It's a one-side narrative. It lacks kind of the full context of the therapeutic relationship. And then what I see on top of that is, that's the most concerning, is that I see a response from other mental health professionals who basically, they don't know anything about that patient, they've never read a case record or a progress note, and they offer opinions and judgments based solely on these little brief clips. And this creates a really dangerous cycle of misinformation where therapists are being scrutinized, basically based on incomplete stories, or and that's potentially fueling legal actions. And I'm seeing this trend kind of grow. And so mental health professionals have got to stay vigilant. Okay. You've got to make sure you're following ethical standards. You've got to maintain meticulous documentation. And I would, if I was you, avoid engaging in any kind of public speculation about colleagues' clinical decisions. Have you guys seen this trend? Has anybody seen this trend? If you're on TikTok, someone's talking about kind of how their relationship with their therapist, and then you'll see another therapist jump in and kind of duet and say, oh, they shouldn't have done that. It's a little bit scary. And I think what people are not realizing is that social media is forever. So if you have a glass of wine and you make a video, that's up there for forever. And so a few people are saying, yes, I have, yes, via TikTok. Yeah. And some people are saying no, and that's good. It started to be kind of a newer trend, and I'm worried about where we're headed. I'm also have some other concerns that there is Robert F. Kennedy. He's made some publicly linked, he's kind of publicly linked antidepressants to mass shootings, citing very circumstantial evidence. And there's no scientific research that supports like a casual link between SSRIs and violent behavior. But he is the chair of Make America Healthy Again Commission. And he is leading kind of efforts to reassess the prescription use of psychiatric medications. And that's raising some concerns as well about potential restrictions and what would be essential mental health treatments, and increase of stigma around their use. And so when we're looking at kind of like a top-down approach to mental health care, this is not only maybe risking limiting access, but it also and this is why you're here today, could empower individuals to pursue legal action against their clinicians, particularly if we have like policies that create an environment where psychiatric treatment is viewed as suspicion or framed as inherently harmful. And then on top of that, therapists might even face greater scrutiny and liability. So this is where thorough documentation and adherence to evidence-based practices really is more critical than it's ever been. And so with the rise of social media and then kind of this top-down approach that we're seeing now. And again, these are just my opinions, so I'm hoping I'm horribly, horribly wrong. I'm hoping I'm wrong. But these are things that we really need to kind of watch out for. So definitely. Now I want to talk to you about the cost of a lawsuit. So I'll move on to the next slide. This is kind of malpractices. They have severe legal, emotional consequences for the mental health professionals. So you're looking at, these are it's 20 to 150,000 per case. And there's a lot of different factors into that. So one is the length of the case, the complexity of the case. What are the attorney fees like? Did you have to pull in expert witnesses? What were the court costs? Like, was the court case settled outside of court, or does it go to trial? And even if the provider wins, you have to think about legal fees alone can be financially devastating. So now there are cases where the settlements are the highest. So I want to talk about that a little bit. Any kind of case involving a boundary issue, those like sexual misconduct, those, of course, those are the highest payouts. Also, if it involves sexual misconduct with, like if you're doing couples therapy and it's the spouse. You guys have seen Ted Lasso. If you haven't, it's a great feel-good show, other than that part. Any kind of suicide-related claims against mental health professionals, those lead to very substantial settlements. So, and then you have your worst case scenario. I like to talk reality based, and then I also speak sometimes about worst case scenarios. And so if you're found liable, some professionals have to pay out of pocket because damages sometimes exceed insurance limits. And you might think about that. Well, I have insurance and it's really, really high. Sometimes, unfortunately, it can exceed those insurance limits, those claims. So, and if you're wondering why, like I have some numbers for counselors, if you're interested in that, and for nurse practitioners. So I can say that from 2020 to 2022, about 10% of psychiatrists reported being sued at some point in their careers, not annually, but some point in their careers. And it's also interesting that female physicians, they actually face lower liability, the risk, than male physicians. There's also a study that was done that said that older psychiatrists had a greater chance of lawsuit. But when you look at studies, you have to look at the fact that, well, yeah, they've been in practice for a long time. So for a longer time than newer. So that makes sense, right? I have some people saying, yes, they want to hear the statistics about what's the average. If you're a counselor, a malpractice claim is usually about 115,000 per claim. For psychiatric nurse practitioners, they said yes, it's about 330,000. These are averages of claims. These are kind of this is the average of claims. Okay. All right. Now I want to talk about some of the things that we can do. Okay, that to prevent these things from happening. That's why you're here, right? You want to know how you can stop this from happening. One, I think the major things with lawsuits are failure to assess and managing risk. So HIPAA violations are a big one. Just in 23, the Office of Civil Rights, they're the ones that are in charge of enforcing HIPAA. They received like 725 healthcare data breaches that were over 500 records or more. Now, if I am doing a webinar, I believe it's next month on HIPAA, but if you have a data breach and over 500 records or more released, you actually have to report that to the public. No one wants to do that. Absolutely no one wants to do that. So, but there were a good number of those breaches that involved about 133 records. And even like a lot of you, I know I see a lot of familiar names in here. If you're using Change Healthcare, that breach affected 1 out of 3 people in the United States. So definitely breaches are a big deal. They're getting worse. They're not getting better. I wish I had some good news for you on that. But when we want to talk about healthcare breaches, The average cost of a healthcare data breach is over $7 million. All right, so it's a lot. So we want to make sure that we don't breach confidentiality. Also, improper documentation. That's improper documentation and malpractice claims, or documentation failures, what I sometimes like to call them, are about 20% of medical malpractice claims. So, and you have this increased liability. So cases with documentation issues are more than twice as likely to result in payments out. So twice as likely as in that. And then you just have common errors. You know, we are individuals, we make mistakes. And so any kind of alterations to medical records or insufficient recording of clinical findings or informed consent, which is a huge one that we will talk about today, those also cause a lot of issues. And I'm really going to harp on informed consent, especially on different types of treatments. Boundary issues, we're back to that, but it is very prevalent in engaging in kind of dual relationships or inappropriate interactions is one of the primary causes. And in England, there's been recently a notable increase of abuse claims on therapists, saying that therapists emotionally abused individuals. I haven't seen that as much in the US, but I'm worried if that's a trend there, that could kind of trickle over. So also negligence in diagnosis. And I do want to preface this by saying that while I'm very much on the side of the clinicians, 99.9% of the time. There was a study that came out in 2023 that said just overall in healthcare that there were almost 800,000 Americans annually that suffered permanent disability or death due to a misdiagnosis or serious conditions. So just there are errors that happen out there and we need to be more diligent with those. I also want to go over, we're just going to talk a little bit about one of the hot spots. How many of you, you can raise your hand, you can comment yes, you can do it in the private chat. And there are 3 ways that you can comment. You can ask questions in the Q&A. That's actually not the quickest. You can use public chat or you can use private chat. Private chat is the quickest. People have found that one, so that's good. I'm going to pop over to QA. All right, that's perfect. Okay. There is a big trend, and this has been going on for a while, but I'm starting to see a trend as well, in false memory implantation and mental health practicing. People are getting sued for this. And so we're just going to talk about it. And because this is one of the heavy things, boundaries issues is heavy, but this has come up a lot. And there was a case, it was an Italian case just a year and a half ago. And the Italian court, they found that a therapist implanted false memories and abuse of a young girl. And what they said was the therapist employed highly suggestive questioning, leading the girl to believe that she was abused by her father. This has happened where courts have ruled against the therapist. This has happened multiple times. And a lot of times I don't know that the court rulings were in fact correct, because therapists are able to get people to remember things that have happened, but you need to be really, really careful. There is also like a movie and a book about Ramona versus Isabella. That was in like the late 90s. It's a really good watch if you're interested. But I want to talk about ethical best practices when you are working with individuals. So open-ended questions. And I think it's great to document that as well, that you're using open-ended questions with individuals, and staying with evidence-based therapies. I'm really big on that. Look, I love new emerging therapies. I think that some of the things that are going on out there are fantastic, some of the newer therapies, but I think that you're safer sticking with evidence-based therapies. Also, really maintaining a very neutral stance. And whenever you're doing anything, as far as working with individuals, I think that you should get an informed consent. I think you should get an additional formed consent with EMDR, even if you're like, well, how minimal are we talking if I'm doing extra therapy? I would say with EMDR, even you would get an additional consent, because that could save, yes, it's additional paperwork. Yes, the patient has to fill out, or client, an additional form, but that could really save you as a clinician later on. So I think that that's really, really important to do that. It's somebody just asked a question about that. I'm going to tell you, it's not a one size fits all in a consent type situation. So it's not a one size fits all. All right, next thing we're going to go over, we're going to talk about documentation strategies for this. What I would say is you would record, and I love verbatim statements, but you record exact client statements instead of summarizing or interpreting them at all. It's just about, in parentheses, they said this. No one can argue with that. And in cases I've seen, individuals do much better when they're talking about the client said this. All right. Also talking about the client's emotional state in context when they're talking about the memories, and then always document the therapeutic techniques you're using, right? And then when the client is expressing any kind of uncertainty about memories, I would definitely document that. And then again, informed consent. And then if you're ever uncertain or ethical concerns come up, I would contact a supervisor or even legal counsel of some kind to speak with them. Those type of preventative conversations can really, really save you in the long run. If the client is, I would also encourage sometimes if the client has individuals that they trust that are reliable sources, they could cross-check memories with, and also to emphasize that memories aren't always 100% accurate, and avoid really, really definitive statements. Okay, those are some of the things that I would do. Someone just asked, will this be a recording? Yes, absolutely. I want to just move forward with the legal and ethical safeguards for individuals. Just to keep you safe, I would always follow APA guidelines, always. And peer consultations, I think, are fantastic for complex cases, because one of the first things I hear people in court say, well, did you consult with anybody else? You knew this was a complex case. You knew things are happening. Did you reach out to anybody? And you have the ability to say, yes, wasn't just you, right? And so I would also stay updated on legal precedents related to memory implantation, and definitely carry good liability insurance if you're going to do that type of therapy to protect against claims. And you're probably like, well, Octavia, why are you harping on this one so much? There's lots of different therapies out there. There's TMS, there's EMDR, there's all types of different ones. This one seems to be the hot spot. And so I just want to caution people about this and keep people in the know. I will say that documentation is always going to be your best defense. And so, and you can see the statistics again as far as why. Even up to 58% of malpractice cases involve failures to properly document clinical findings or your rationale for clinical decisions. So it's really important that you document informed consent for all types of treatment planning that you're doing. So the proper documentation is absolutely essential, that the clients were aware and they agreed to your treatment planning. So some states even require, like if you're working with Medicaid, they'll want the client to sign the treatment plan, right? So that they were invested in their care, that they knew what their treatment plan was. So any type of failure to document this informed consent really can lead you down a road of a lot of legal challenges, and it can undermine that kind of therapeutic alliance as well. So, and I would write really, really clear and objective progress notes. Again, verbatim statements, tell a story. Now, there are several people that I follow that are documentation specialists, and they will say, well, you don't want to tell a story, and I think that in your documentation, you do want clarity and you do want precision in your documentation. But I think you should tell a story, and here's the reason why. We've already kind of briefly talked about cases. If your client or patient commits suicide, that will be under scrutiny. All right. And there is a very high percentage that you will get sued. And no one ever wants to hear or really talk about that even. But unfortunately, we work in mental health. And this is just like cardiologists, they experience individuals who have heart attacks, even though they've tried to prevent them from having heart attacks, that this is what happens in mental health. Okay. This is it's a reality that happens, and it's sad, and we don't ever want it to happen. And we have lots of wonderful initiatives like the Zero Suicide Initiative, lots of fantastic initiatives out there to prevent this from happening. But in reality base, it will happen. And so as a clinician, you need to be prepared, and you can put in verbatim statements that can very much help you. When your clients tell you that they are sad and depressed and that their family may be cruel to them, or that they are having difficulties with their family and no one is helping them from their family, and just all of the things that they say, those wonderful verbatim statements, this is an opportunity for you to put that in the note. And let me explain to you why. I'll give you a specific situation in which a patient suicided and the clinician was sued. And they had done a really beautiful job of documentation, a really, really wonderful job of documentation. And in that were verbatim statements by the patient that says that their family was not helping them. You know, they wouldn't give them any help, any guidance. They were emotionally cruel, all of the things that the patient said. Well, guess who sued when the patient committed suicide? It's the family, right? And so I think it does help to tell a story, because a lot of times if this goes to a jury, they are all lay people. They don't understand what the standard of care is. And you may have done an excellent job with this patient. You may have worked with them and done everything you could as a clinician. So I know most of you in here that are clinicians, you really work harder than the patients do sometimes on those short-term goals and long-term goals, right? I know that. And so, but unfortunately, you know, you work harder and they just decide not to do it, right? But telling a story to individuals who are especially lay people is extremely helpful on everything that you tried to do for that individual. Okay, because sometimes when you're in those legal situations, the standard of care, which is really clear to you and I because we all went to school for it, can be manipulated. Okay, it can be manipulated. So how many of you use verbatim statements? Just wondering, how many of you use verbatim statements? You can type yes in the chat. Sarah, okay. Somebody said every session. Yes, absolutely. Good. I love that. I love that. That's great. That's great. Sarah, you had a really good question. And I'll go to Bethany first. Why do documentation specialists suggest not telling story? There's a couple out there, like there's a lady called the Documentation Wizard. There's several people that are like, don't, and there's several people that I listen to, okay? Because I like to get feedback from other folks as well, because I see what works, I see what doesn't work. But I like to get feedback from other people. And I heard the lady, a well-respected lady, I follow her for a lot of I love to listen to her talk. I think she's an excellent speaker, but she said, don't tell a story. And I was like, I don't agree with that at all. I agree with her on pretty much everything else, but not that. So I think you do need to tell a story. So absolutely. Quote everything. The reason she says not to tell a story is because if your documentation is pulled, then they really want just kind of clear, concise things. She doesn't want you to over document, and I don't want you to over document either. I think you should use clear, concise statements. One of the reasons that iCanotes is the EMR that we are is because you can click a button and it gives you a very clear statement. An attorney cannot read into it, right? And it's just clear, concise, it's professional. So, and I think maybe she doesn't want people to get too wordy in there. So, but not having enough documentation is equally as bad as having too much. So, Sarah says, I have experienced confusion about documentation and best legal practices. I'm told to think about what the insurance company needs to know, but in this legal context, shouldn't notes be highly detailed? You're absolutely right. The insurance company, they're going to go through and make sure that you hit kind of all the highlights because they're not going to want to pay you, right? And I'm sorry, I'm a very reality-based person, so insurance does a lot to try to get clawbacks. And so they want to see things in the note, which I think you can definitely speak to insurance, right? This is what they want to see. They want to see that you did the assessment, depending on your discipline. You know, if I am, let's say if I'm a provider and I'm billing out an add-on psychotherapy code to like my nun 2 and 3, and I put my add-on psychotherapy code, they're gonna want to see a treatment plan, right? If they're real picky, they're gonna want it signed by the patient. And so you're going to have to check all those boxes, right? If I don't bill a psychotherapy code, but I add like a 99214, 99215, then I'm going to have like some kind of collateral documentation. I'm going to need to have done some testing, whether they're on Depakote and I got the test and read it, something like that. So they're going to see that you checked all those boxes from the insurance. I will tell you though, if I'm in a position that I have to pay back insurance or I have to go to court legally, I'm going to want to pay back insurance, right? So for sure. On a couple claims, absolutely. So I do believe that notes should be detailed and kind of structured of what you did. Like these were their verbatim statements. This was why I helped them. I gave them, I allowed them verbally, to talk to me about them. I gave them emotional support. Those treatment plans, like I encourage journaling or exercising, or we're going to monitor their PHQ-9s, and I'm going to bring that in a little bit more because I love, well, actually that's the next thing on the list was evidence-based risk assessment tools. You can get a lot of trouble if you don't use these. So I would encourage everybody to use them, because the thing is that you saying they're depressed and they're saying they're depressed, we know they're depressed, right? But a scale, an evidence-based valid scale, is always really helpful. Okay, because you actually have numerical numbers on there that can tell, yes, they're PHQ-9, if they're a 13, they're depressed, right? Another scale that I absolutely love, and I will encourage you to use this on every single visit, and you will say, October, I don't really want to do that. That's not my general practice. My patient and my client, we have really good rapport. And so I don't want to ask them every session if they're suicidal, because I don't think that that's therapeutic. And I hear you 100%. Right? So, and as a patient or client, I'm sure they don't want to be asked every single time if they're suicidal. But I'm telling you, the time that you don't ask them, that's going to be the time that something happens, and you don't want that to happen. The Columbia Suicide Severity Rating Scale has 2 or 3 questions that are very, very simple that you can actually bring into the conversation. You can fill that scale out later on. If you don't want to have that conversation with your patient, you can put it in the portal and have them fill it out. Each time you see them, they need to indicate, you need to find out whether they're suicidal or not. Okay. And that one time that you don't ask will be the time that they leave your office and something happens that was completely out of your control. Because a lot of times when you get your patients or clients in your office, you are able to get them to where they need to be therapeutically. You are listening to their concerns, you're offering them coping skills. They are great when they're with you, or even if you're doing telehealth right here, we are great. We're having great conversation. They're doing really well, and something completely will send them off the rails. And you had nothing to do with it, nor will you ever know about it. And so I think doing suicide assessments, you can use the CSSRS, because if your patient commits suicide, they will ask you, what assessment are you using? And that one is considered the gold standard. So I would use it. And I will have some people that say, I don't really like that one. So, and I do like it. I think it's a great scale compared to a lot of other scales. I think it's a great one. But I think it's the best one? No. But I think it's a great one. But it doesn't always matter what my professional opinion is. It also matters what people want you to use, and that is the golden one right now. So absolutely. Angelica said, yes, quote everything. Love quotes. Love quotes. So my clinical has told you to write less. I think there has to be a really happy medium. I think that there has to be a really happy medium. So I do. The thing about that is short and I like notes that are short and pointed, but I think you should add things in there. So, and writing less doesn't mean like a four lines. I wouldn't do that. But just a short, like a mental status exam, which is good to do on everyone. A mental status exam is not, that's a lot of writing. There are a lot of elements to the mental status exam. So absolutely. When you're under clinical supervision, because especially by different supervisor types, I think you made a really good point, because a lot of people have different ways of doing it, and not always are ways of everybody doing it right. And there is no standard, concise, like right way. But what I will tell you in the note, if it was me, what I would put in every single note is the assessment of the individual, how they said they're doing. These are where your verbatim statements go, right? So then if you don't want to do a mental status exam, which I understand, every visit, it's a long, I would definitely hit the high points of the mental status exam, okay, which is are you suicidal? Are you homicidal, right? What's their appearance like? Are they, when they came in the office, are they showered? Are they cleaned? If I'm looking at them on camera, like, are they dressed kind of appropriately? So what is their speech like? Those types of things I would definitely put in my assessment. So you could have that. Then I would put our verbal, like what they talked about, like what I talked about with them, what were the therapeutic interventions. And then I would always, always, always refer back to your treatment plan. Whatever treatment plan and listen, treatment plans are the bane of everybody's existence, right? They really are, to a certain degree. Some people love treatment plans, and I applaud you if you do. Okay. So, but I would always go back to that treatment plan and what we're working on the treatment plan, because we can always say we're working our plan. This is how they were doing. We were working the plan. So they began treatment with me. We were working that plan, and we bring it up into every single session. Absolutely. So, all right. I don't have to tell you this one, avoid retaliatory or subjective comments in the records. I would not make subjective comments in the records at all. And you do have to watch your tone when you're documenting. Again, iCanotes is really good for that, because there is no tone in the way that when you use our buttons, there is no tone in that. But it is, I would be really, really careful about that tone, and just focus on this is what I observed their behavior was. This is factual information. Timely documentation. I know this is hard for some folks. Some folks are very good at getting their documentation done right away. Right away. If you are one of those people that you get it done immediately after the session or the day of the session, you are above average. Okay, you are not the norm. All right, but it is best practice to try to finalize and write notes immediately if you can, or just at least within 24 hours of the session, to ensure accuracy, to ensure completeness of the note. But what I will tell you is delayed or backdated documentation can really raise legal red flags. And it can weaken really, truly the credibility of clinical records in courts. And that is not me saying that. That's the APA said that. They came out and said that last year. But I had already seen that, and just dealing with, unfortunately, I've had to deal with federal and state agencies for a long time throughout my career at iCanotes. And so I had already seen that trend within 7 or 8 years. They absolutely love it when your documentation is not anywhere near when you actually saw the person. So, yep. Oh, all right, let's see. Just looking at yeah. Here's the thing. A lot of people are saying I'm under clinical supervision right now and I'm being told to do that. The great thing is, well, you're under supervision, so you have to do it the way that they want you to do it right now. But when you are not in supervision, you can really use documentation as kind of your best defense. So I think that, yeah, absolutely. Absolutely. So like I said, I was always told to create a breadcrumb trail with specifics that are pertinent. I like that. I've not heard that terminology before, but I really like it. Exactly. You're kind of like, so if all the notes were put together, it would be kind of like a trail. Exactly. So very, very good. Very, very good. I would also be really careful about copy and pasting your note. I know it's easy. I know a lot of people do it, but you do not want to have notes that are copy and pasted, like the same note over and over again. If you're in a liability situation, that is not going to go well for you. So absolutely. Now, what some people do, and I like this, is they'll bring in the note from the previous session. I like that. I think that's great because that shows two things. One, you are looking at the note, right? You're looking at the note and seeing what you talked about last session. That's a good clinician. I'm going back to, because you have lots of people that you're seeing, so you cannot remember, especially if you're a provider. So I know some providers are seeing up to 24 patients a day. So you're not going to be able to remember that patient. And I will tell you, unfortunately, every single time, this was without fail, when people got sued, they don't even remember the person that is suing them, because sometimes it's 2 to 3 years down the road. So especially in provider situations. So they're like, I know that name, but I can't remember the situation. So your documentation is the only thing that you're going to have. All right. So next thing I want to kind of talk about is, let me move over the slide, is informed consent. What you need to include in informed consent. And I'm really going to harp on this because this is definitely, I see people that just use generic informed consent, but they're in a state, and there are some hard Medicaid states. There are about 5 or 6 of them that are really tough Medicaid states, and they're a Medicaid provider in the certain state that's really tough, and they're just using an informed generic consent. I would not do that at all. So only 26% of consent forms actually include detailed, like the treatment purpose, the risks, things like that, the alternatives, when they did a study 2 years ago of consent forms. So vague descriptions can really lead to client misunderstandings. It can definitely lead to legal issues. The Joint Commission just came out and said something about this last year, which was really interesting. But I think that many of the consent forms really fail to disclose kind of all the discomforts, right? And so clients have to understand that informed consent and be able to make decisions based on that. Another big topic that's coming out is like these good faith estimates. You know, it's federal law that if you're out of network, you give someone a good faith estimate, and people aren't doing that. And there was no movement on that. Like no one was really getting in trouble for that. And now I've started recently to see movement on that. How many people here are aware of the good faith estimate? Have you heard about them? Do you use them? We've got some people. All right. Great. Great, great. Good faith estimate is something, it's really confusing for individuals. So just, you know, that's something, I think we have an old webinar on that. Maybe someone can post that in the chat on the good faith estimate. But it's definitely, if you're out of network, if you take a lot of folks that are out of network, you're supposed to provide them a good faith estimate. So for sure. I think that just with these things, to know that is a lot, it's very important to get a client signature on this, whether you're using this like you're doing paper or using it electronically, and make sure that they really sign it. Some clients get cute and they put like an X, or they will fill out a name that looks like their name, but that's not their name. And I'm not saying they had malicious intent when they're going to do that, but that's come up several times. So make sure that's really their name on the signature. Why this is problematic, I'm not sure, but it is problematic. And don't use vague or outdated consent forms. I cannot stress that enough. If I'm practicing in a state, especially if I'm taking Medicaid or Medicare, I am going to use a form that is state specific. Okay, a form that is state specific. All right. And I would really look about, check out confidentiality limits like harm to self, harm to others, court orders, And I think that clear explanations in your consent form will prevent disputes over confidentiality breaches. And let me explain why. Your duty to warn, you've got to think about that, like your duty to warn, that needs to be outlined clearly in your confidentiality, or excuse me, in your informed consent. So they, like, you sign this informed consent, it had duty to warn. And then I would also document that if you have any specific cases where you realize that may come into play later on, you can talk to them about duty to warn, right? So, and that you won't have any confidentiality breaches if you put that in your informed consent and give a clear explanation to it. And I think what happens with a lot of clinicians is that they really are like, they don't kind of want to enforce a lot of these things with their clients, because they're like, of course your client and your patient is there, you want the best for them, they're of your best interest. But I have seen this happen so many times, so I want to be very clear that a lot of times people, when they should have sent, maybe when they should have petitioned a client because of suicidal thoughts, they should have done a duty to warn, but they didn't. And they didn't want to mess up their rapport with their client. And I know a lot of you feel that, like you feel very strongly about, the client, we have rapport, we have trust. I don't want to break that. But at the end of the day, and in certain situations, if you don't handle them correctly, you could not only, it's not that client you're not then worrying about. You have hundreds of clients and patients to save. And if you are not handling things correctly with that one client, that could prohibit you from helping all those additional people. And I know a lot of people get caught in their head and they think about that, like, well, I probably should have petitioned them, or I probably should have done that duty to warn. If you're feeling that in your gut, because you all have really good guts, if you are feeling that in your gut, then you should petition them, or you should do that duty to warn. All right. So absolutely. Absolutely. So, all right. You're saying, someone says it does feel redundant with my informed consent. Yes. Yeah. Mandatory reporting. Exactly. So, all right. All right. So again, I can't stress this enough. Follow your state guidelines with your informed consent, for sure, for sure. All right, I want to answer a couple other questions here, and I'm going to get to these in the chat. So there's folks that are private messaging me. Thank you very much for that. There are folks that are private messaging me, putting stuff in QA, so I'll definitely address that as well. Let's see. Okay. And then let me just grab these. Jana's wonderful. She's got a spreadsheet of your questions, so I'm definitely going to get to them. And I'm going to speed up, so we'll have a little bit of time. All right. Thank you for saying that. Thank you. I want to talk about the danger of boundary violations. I don't want to stay on this and talk about this a lot, but this seems to be a problem. 44% of malpractice allegations are related to this. So that lets you know that sexual romantic relationships are a problem, unfortunately. And this is seen more between counselors and therapists. But engaging, again, in a dual relationship that can give you, you could definitely get in trouble for that. So please make sure that you're not doing that. Breach of confidentiality is another one. If you share client information, that's a frequent basis for complaints, because sometimes your patients or clients, you did not share information, right? But they think that you did. They're suspicious of you. They feel like someone found out something about them and it must have been you that told. So just be very, very cautious about that. I also encourage people just to let them know, everything you say in here is private, unless, you want to hurt someone else. So kind of letting them know that and reinforcing that. So Those are definitely some things that, again, boundary violations, they do happen a lot. So you always have to maintain professional boundaries. You always have to secure that or ensure that all interactions remain professional within the therapeutic context. And you need to make sure that you secure your information um, properly and you stay very informed about ethical standards. And so there was recently a case, well, it was last year, there was a therapist, her name was Elizabeth, she was in Florida. She was charged with sexually abusing a 15-year-old boy that she counseled, and the abuse occurred like during one-to-one sessions at a hotel room, and she booked specifically for that purpose. And then she also was like giving this minor vape pens and alcohol and giving the minor monetary gifts up to like $9,000. So this is happening. And then if you go and look at the SAGE journals, it will show you that depending on where you're located, that 1 to 7% of therapists have engaged in sexual relationships with your client. And you're like, listen, that sounds like way too much. That's not correct. People that are in my profession are professionals, and I agree with you 100%. But there was another publication that came out. It was a study that said that 70% of therapists reported feelings of attraction towards their clients. The great thing was, though, that only a small fraction of them acted on them. So, and I, for a minute, I was like, who are in these studies? Who are in these studies? But this is statistical data. So, and there is a difference in attraction versus action, but just, the APA strictly prohibits sexual intimacy with a current therapy, a client, or patients. And they are clearly state that you must not engage in sexual intimacy with former clients or patients for at least 2 years after the therapy ceases. And that is just, and that part is there has to be like stringent circumstances for that. So the APA, those are their guidelines. And you might think, well, I'm never going to have a problem with that. Well, there are a lot of people that think that, unfortunately, and it is happening. And what I will tell you, that I know what the APA says of 2 years, but here's the thing: I never, ever, ever. And if you're a provider and you gave a diagnosis of major depression or bipolar disorder or any kind of diagnosis, and you started treating them with medications for that diagnosis, even if they haven't seen you, but they continue to be on those medications and they're no longer your patient and they haven't been your patient for years and years and years, they are still at a liability risk because you made the diagnosis and you gave them medication. And if they're still on that medication and they start a relationship with you, that is big, big problems. Does that make sense to everybody? I don't want to harp on that anymore, but I was kind of shocked about these statistics, and I wanted to share them with you. So absolutely. Let's see. All right, so let's move on. Just got a couple more slides here. Social media and digital communication risk. I just want to be, I want people just to be very much aware of that social media is forever. And I'll tell you about a post I saw the other day that, because I think inappropriate self-disclosure is not okay, especially when therapists kind of share personal information that your client doesn't even need to know, right? It doesn't suit their therapeutic needs in any way. It can disrupt that professional relationship. And that disclosing those kind of things can shift attention away from the client onto you, right? For like fulfilling your personal needs. So if you're a mental health professional, do not do that. Like, stay in your role. Don't let that lead to any kind of confusion. There have been some notable court cases involving inappropriate self-disclosure, and I wish I had time to go into them because some of them are really juicy. But what I will say is what I saw the other day was there was a social media post, and the woman was saying that she had post-election trauma and she had a great relationship with her therapist, and then her therapist basically took up for an individual and said, I voted for this person and they're not bad like you think. And the person was talking about how it ruined their rapport. And so, in therapy, or in reality, the therapist should have never said a word. Okay. So do not self-disclose. Okay. And here, what I will tell you on that particular post is the comments section was really scary because everyone was telling her to sue her therapist. And another therapist then started duetting the video and empowering this woman to possibly sue. So that's why I want you to be really, really careful. Do not disclose if you don't need to. Your opinions are your opinions. What's that saying? We listen and we don't judge, right? So you do not share. If you want to share about, like, yes, I know that restaurant and it's really great too, that's awesome. But as far as those kind of personal things of self-disclosure, don't do it. It will cause you more problems and potentially not cause any good. So just protect yourself. All right. And I'll tell you something that I had to do the other day with Iconotes, and I encourage you to do this. And this is just something if you're going to use a picture that like for your website, or if it's on like a Psychology Today or whatever it is, I would use a picture that is not associated with any other social account that you have, because what people are doing is, your name may be different on social media. Most all of my friends are in the mental health profession, and none of our names are our actual names on social media. So, but what they will do is they'll take that picture and they'll Google search it, and then they can find your personal social media sites. So just be really careful. Don't use a picture of yourself that you don't use on any other platform except professional platforms. So that is kind of that's one of my things that I'd like to say. As far as other issues, I think mitigating legal risk is something that, always maintain up-to-date documentation. Get your malpractice insurance. Again, I cannot stress enough on your consent forms. And another thing that I'd love to hit on right now is safety plans. I love a safety plan. Safety plan is different than a safety contract. A lot of people are like, look, contracts don't work. They won't protect you in court. You're absolutely right. They won't. But safety plans are different. And a lot of people, if you are doing all the things, if you have them fill out the informed consent, you've got the great documentation, you're going through your treatment plans and you're referencing those every time you see your patient, and you've got a good safety plan in place, you're probably going to be good. So how many of you, just out of curiosity, how many of you use safety plans? How many of you use safety plans? Got quite a few. Yes. All right. Fantastic. Love safety plans. There's a safety plan in Iconotes. There are other safety plans out there, but yeah, it's great to have a safety plan and then have a copy of that. Somebody said a crisis response plan. I like that. I like that. They're difficult to create in the moment. I totally agree with you. Yeah. There's a lot of apps out there. Absolutely. Absolutely. So fantastic. Very good. Safety plans are great. They're absolutely wonderful. Love safety plans. All right, excellent. And then what I cannot stress enough, if you are going to get those complex cases, you are going to get them. They're going to happen. Most 99% of your cases you'll be able to handle by yourself. No, not a big deal, but it'll be that 1%. And so I always tell you, just go with your gut. If you feel like you need to report. And then also if you just get with an expert that can help you. So that's a good question. I was actually thinking that, Norma, when you said that, you said, if they use the app, do I need a hard copy? I was actually going to say that and then refrain. I think apps are great. There are a lot of good apps for mental health out there, but I want a copy. As a clinician, you want a copy of their safety plan, right? And on an app, you don't really get that, right? So you definitely need a hard copy. So absolutely. Julie, I will tell you, so one of the things about this website is we're just talking to you today about how you can help protect yourself. This is not a sales pitch at all. Of course, we want you to use Iconotes, but because it's a fantastic program. But I can suggest some good malpractice insurance companies. I'm not affiliated with any of them. So anything I suggest to you, I don't affiliate with anybody. So anything I suggest to you, these are just companies that I've heard really good things about, or like friends of mine use. Absolutely. So if you send me an email, and I'm happy to answer your questions, because I don't think I'm going to get to all of them, right? Because we are running, I went way over, and I am super sorry about that. So I'm real sorry about that. So, but I do want to get through this next little part. So I'm just going to go to final thoughts here. and I mean this from the bottom of my heart, this is proactive risk management. And that's what you need to do. That's what you need to do. So of the things that we learned today, I'd love for you to type one thing in that you would start using in your practice. I'd love for you to type that in. And I am going to get to your, because you got some really good comments there. So, all right. So let's go to, let me grab these comments. I'm sorry. It's on a different screen. So I'm having to look at this other screen. If you're like, why are you looking to the right? Then that is why. So we had a question about certifications and trainings and like legal boundaries. And I just kind of want to go over that, like what you can, somebody said, well, what determines what I can do? All right. And most of the time your scope of practice, and everybody in here has a scope of practice that's written by their state laws, those licensing board regulations, those professional standards. And also it depends, like you could be an individual who you are licensed, but then you have these additional certifications and trainings. So that's one thing, but it's always licensing boards and state laws determines who gets to do what, right? And that is on kind of the granular level of in your state. But then you have these organizations that you work for, like if you're employed, that have internal policies about like, and sometimes workplaces, like they'll say, well, this person can't do this, you know, and you're like, but I can do that. The state says I can, but according to the workplace, you can't. So absolutely. So that's one of those things that, you know, as far as who determines what you can do, it's the state, but then it's also your workplace. Now, I will tell you, there are insurance companies, so you need to be really careful. There are some insurance companies that you are like, I got insurance, I'm good to go. And if you look real deep into your policy, there's certain things that they won't cover. Right? There's certain things that they won't cover. Like maybe they'll cover regular kind of like therapy for ADHD, but they will not cover biofeedback therapy. So you need to like look into those things as well. So there are a couple different organizations. That's a real quick answer to your question, but I hope that that was helpful. The other question, okay, I've got a couple. Over documenting. Okay, definitely. So I would not include an over documenting. There's some things that I wouldn't include. Like I wouldn't, for insurance companies, and a couple of people have you mentioned that, like, well, I need to document this way for insurance. Yes, you need to justify a medical necessity for insurance, right? Not extensive like personal details, right? So, I mean, that would be, you know, oversharing. I think, again, verbatim statements. All right, verbatim statements. So love those. I would also not speculate in any notes or make any kind, I would not document anything about subpoenas in there. Like, so you're like, well, what would I not document? I wouldn't make any kind of legal statements or speculative statements about a client's legal situation or anything that they have like abuse allegations on there or anything like that. I wouldn't document that at all. So I would just stick to like client said this, reported information, no additional conclusions. So absolutely. When is too much too much? I think you have to keep it relevant to medical necessity, right? I wouldn't really avoid any kind of unnecessary like third-party disclosures. Like, well, their boyfriend is being, you know, has things going on with the police because of these allegations. I would not in that. I would just say that there are concerning legal issues to this client. Things like that, over documenting. No subjective statements, no speculative statements at all. Always clinically appropriate language. So absolutely. What are some other questions? Wait, don't document that you're a mandated report. No, you have to, now let me say this. You have to report. You have to report. When I'm talking about oversharing on third party, meaning like, and I hope I clarified it with that statement, I would say something like, let's say the client has a boyfriend who's been accused, or someone is alleging that they have been abusing individuals. I would not put that in my note. I would absolutely not put that in the note. So now mandating reporting for child abuse, that is absolutely, you have to do that by the state. I didn't even talk about that because that is, I feel like that's a guarantee. So absolutely. Absolutely. Pending divorces. So that's a good question, Chantel. What about pending divorces? I would say something about that they are having marital strain, right? That absolutely. The only you have to take into consideration is, will someone come after your notes? Now, how many of you guys are aware of the open notes policy, information blocking? How many of you guys are aware of those? If you're aware of that particular law, you now know that clients can have access to their notes. And that includes mental health progress notes. What it does not include are psychotherapy notes, right? And there's a lot of confusion around that because people are like, well, and so there's multiple notes that people can't have, psychotherapy notes and notes, and I hope this clears this up, that have any kind of legal proceedings to it. And legal meaning civil, divorce. It could also be criminal. So if they said anything in their notes about anything like a divorce or criminal proceedings, or it is a psychotherapy note, the patients do not have access to those notes. Now, but here's the problem. Those notes can, in some cases, that you can get a subpoena for those. So I'd be really careful in certain notes, especially if you're doing couples therapy. There are a lot of pitfalls in couples therapy with notes because people will try to come after notes. That doesn't mean they always will get them, but that necessarily doesn't stop them from trying. So absolutely. A lot of questions here. Suicide rating scales in addition to the PHQ-9. PHQ-9 is depression, but the suicide rating scale that I'm going to recommend everybody use is the Columbia Suicide Severity Rating Scale. It's like in 114 languages. I believe that the validity of the score is really, really high. They did a post-mortem study of how many people came into the ER and this is a true study out there. It's a little scary. They did the Columbia Suicide Severity Scale, and they said how many people were at risk of killing themselves and how many people did kill themselves, and that number was actually staggering with that when they did that, but like a post-mortem study. So I would use the Columbia Suicide Severity Scale. No one will ever say that that was not a good scale to use, and I think it's an easy scale for clinicians to use. It's just a couple questions. So that's a good question, Brittany. Can psychotherapy notes be used in court if they would protect us in a suit? Absolutely, they can. If you are being sued, absolutely, they can. So show a copy of the Columbia Suicide Severity Scale. Okay. Give me just a second. Well, I don't know if I can share my screen. That's a problem because they have my slides loaded up. But you can just type in Columbia Suicide Severity Scale. Recent there's a lot of different ones. There's a safety T. That one's pretty much that's a big scale. But the recent or past visit is the ones that I would use. So those are real. It's again 2 to 3 questions. So I do have some other questions. I'm really scared I'm not going to be able to get to these. Let's see, scope of practice. I went over that. Legality on therapists can diagnose specific disorders. I think I went over that. Talked about writing too much. Is there a best practice for reporting suspected child abuse? Do you tell them or not? What does it depend on? Well, that's definitely a loaded question. That is a loaded question. So I think that, and what I will tell you is, and I had some notes that I actually skipped over because I didn't have time to go over that. But what I can say is that there have been legal consequences to that. So, and let me tell you a little bit about the legal consequences. So that'll give you kind of an idea. If you fail to report suspected child abuse, that can have not only legal consequences, but professional consequences as well. So there can be criminal charges, right? You know about that. Like in Maryland, there was an individual that they failed to report suspected child abuse, and an admission like that is considered a misdemeanor. and punishable in jail up to 3 years. Now, I say this all the time. I am not a pretty person, but I'm too pretty for prison. Okay, and a $10,000 fine. So it depends on really the state. Like if you're in New Jersey and you don't report child abuse, it's classified as like a 4th-degree crime, and then you get like 18 months in prison and 10,000, or both. You could get both. So there was an LPC, LPCC, that was treating a foster child and just failed to report concerns of abuse to the appropriate authorities, and that led to legal action. And because what the counselor said was they breached their mandatory reporting duties. So just here, I will tell you, you need to familiarize yourself with your state-specific reporting laws. Because like in North Carolina, I'm in North Carolina, the mandates report not only for abuse and neglect, but also for juveniles who have been victims of certain crimes. So always make sure you know your state laws and document. Funny state law is corporal punishment is not against the law in North Carolina for children. So yeah, I didn't like that. But know your state laws, okay? And they change. That's problematic that they change. And whatever you do when your documentation, you're always going to document the rationale behind your decision to report or not report on suspected abuse, okay? But I'm going to go back to telling you that and I know you don't, so a lot of times you're like, I don't want to do duty to warn. I'm thinking twice about reporting. I don't want to petition them. Whenever your gut tells you to do something, you just need to do it. You need to go ahead and do it. I always talk to people who are sad that they didn't listen to their gut, right? You're smart, you're well-trained, you're well-educated. Listen to your gut. All right, we are way over at this point, way over. So in Ohio, we're mandated reporters for animal abuse. I am really glad to hear that. So I appreciate you guys so much. I appreciate you being in this webinar today. We do have iKnotes as a program. I'm going to do a quick little demo of that and talk a little bit about how it helps with your documentation. So how many of you are iKnotes customers? If you are, just say yes into the chat. Yes, I'm on iKnotes. There's a lot. There's some people in here that are, and there's some people that I'm not familiar with. So yes. Okay. All right. Excellent. And for folks that have to go, I completely understand. I've gone way past the point. So I just appreciate you guys hanging in here with me today and all the good questions and all the fantastic chats. So I think that's absolutely amazing. So great insight here. What I am going to do is I am going to share my screen if I can. So let me just stop this. I'm going to remove. Okay, and we are going to share screen. Okay, so this is iKnotes, and it does verbatim statements for you. So I can say client has symptoms of, and I can come in and say they have depression, and that depression is present. And if it's chronic, I can put that, and I can say maybe their appetite is poor and that symptom is present. Maybe they have fatigue, and that's actually been a little bit worse in our past visits. Their irritability that continues, and that's worse. I can say that they have feelings of worthlessness, and that symptom is definitely present. What verbiage that I really like is suicidal. They're not suicidal, but their denial is convincing, because just putting they're not suicidal is not enough. You need to talk about if you believe that they're not suicidal or not, because anybody can say, well, I'm not suicidal, but is that denial convincing to you? So as a therapist or as a provider. So absolutely. And then I can go in and talk about their behavior. Like, are they taking their medication? Is that regular, right? What's their functioning at work like? Is that marginal? All of those different things. I can talk about their sleep, like they have sleep problems, falling asleep and staying asleep. I can also talk about verbal content, like maybe they're having problems at work. And then what's going on there? Maybe there's depression going on and they have some anxiety as well. And what did I do for that? So maybe the session goal was I was just talking to them about their communication skills or maybe their coping skills. can be both. And their interventions that I'm doing there is I'm supporting and I'm encouraging them to vent their feelings. If they're doing well, we talked about the mental status exam. Those are really important. If they're doing really well, I can hit normal and move on. It will put the patient's name in and their gender, and then we can move on from that. And so I'm able to also put other things in. As far as one of the things I really like is justify level of care. This is the way that you get more sessions for your individuals. Like outpatient is still needed because it's interfering with their day-to-day activity and they're unable to self-alleviate. That's perfect terminology for someone saying, listen, they need more sessions. They're doing okay, right? But they're still, their day-to-day activities, their depression still, they're unable to self-alleviate it. So we've got to work together more. So you're able to put diagnosis in here really, really easily. You can add them by code. If you're like, I hate ICD-10, well, unfortunately, I hate to tell you, 11's coming out, but soon. But you can also use your DSM codes and convert them to ICD-10. So you're able to do that. I'm able to link in my treatment plan. So whatever my treatment plan is, I can link that in and pull in specific problems and talk about, because what they care about is, especially insurance companies, especially if you're billing for psychotherapy codes or if you're a therapist and you're billing for Medicaid, they want to know how they're doing with their treatment plan, like what progress are they making, and what are you going to do with the treatment plan? Well, I'm going to continue it. So, and then I can link that directly into my note, and then I can compile and preview my note. And this is a good hearty note. The things I was missing was I didn't put a verbatim statement in for my patient. I needed to do that, right? But I've got their history, I've got their behavior, their verbal content, psychotherapy, their mental status exam, medications if they had it would be in there, and their instructions and recommendations and plan. That is a good hearty note, and it's gonna be hard for someone like an attorney to read in a lot into that. And then of course you can electronically sign it. So that's Iconotes. That's kind of how it helps you with those statements. So somebody said, how do you feel about AI? I have a lot of thoughts on AI, but I also see some other things. If you say denial is convincing, should you state their verbatim contents? I love that. Yes, Greg. Like their denial is convincing because they said that they couldn't leave their dog. They love their dog and they know they don't have anybody to take care of their animal. So yeah, absolutely. Absolutely. So you can say denial is convincing and that's enough. But if there are verbatim statements and they say them that back up that, I would definitely throw those in. So absolutely. Can I pay the link for the next webinar? No paying. So nope, this is all free information. Absolutely. It is recorded, so you will get it. I appreciate you guys being here. The HIPAA webinar is next month. I don't know if they have that linked up or not, but I'll make sure that gets sent out to you though, because a lot of information with HIPAA that I want to go over that I wasn't able to cover today. But I really, really appreciate y'all being in here. Thank you so much for joining us, and I hope you guys have a wonderful day. All right. Again, love the questions. Do you need a treatment plan for psychotherapy add-on? Do we need it for med management only? If you're just doing med management and you're doing a 99213, I wouldn't worry about a treatment plan. I mean, they want you to have them, right? But if you're doing a 99214, 99215, definitely a treatment plan in there. Yeah, or insurance a lot of times will kick it back. All right. Thank you guys so much. Thank y'all. Y'all have a wonderful day. Again, thank you for hanging in. All right, take care. Bye-bye.